Hello friends, in the series on income tax cases, today we will discuss the importance of draft assessment order which is there in section 144C subsection 1. In the present case, the issue before Delhi ITAT e-bench was that if the assessee is an NRI which is an eligible assessee according to section 144C subsection 15 clause B, and if the assessing officer passes the assessment order without issuing assessee any draft assessment order, so whether in that case the assessment should be quashed on the ground that the assessment has been completed without issuing the draft assessment order to the assessee. This issue has been decided by Delhi ITAT e-bench in the case of Shri Prakash Kundan Das Bajaj versus Deputy Commissioner of Income Tax, Central Circle 8. The reference number of the case is ITA number 2797 Delhi/2026 and the date of the judgment is 13th July 2026. The present case relates to the assessment year 2021. The assessment proceedings of the assessee were going on and there was an issue of unexplained commission income of near about 37.08 lakh. In the present case, there was no doubt that the assessee was an NRI, and section 144C subsection 1 says that in case of an eligible assessee, if the assessing officer wants to make some variation in the returned income of the assessee which is prejudicial to the assessee, then the assessing officer has to issue the draft assessment order. Now, if we see section 144C subsection 15 clause B, in the eligible assessee the non-resident Indian also comes. In the present case, there was no doubt that the assessment of the assessee was completed without issuing any draft assessment order to the assessee. Some additions were being made, and when the matter was before the tribunal, the assessee raised the issue that in the present case the assessment has been completed by violating the provisions of section 144C subsection 1 read with section 144C subsection 15 clause B, that is, the assessment has been completed without issuing the draft assessment order to the assessee. When the tribunal heard the matter, the tribunal said that in the present case, there is a failure on the part of the assessing officer to follow the mandatory procedure under section 144C. The tribunal said that not following the procedure under section 144C subsection 1, the assessing officer has curtailed the assessee's statutory rights. The tribunal was of the view that issuing the draft assessment order is not a mere procedural irregularity, and the tribunal was of the very considered view that it is a legal imperative that deprives the assessee of statutory internal review rights and mechanism like approaching the dispute resolution panel. So the tribunal quashed the assessment proceedings in the lack of issuing the draft assessment order by the assessing officer. The tribunal said that other grounds relating to unexplained commission income under section 69A amounting to rupees 37.08 lakhs were rendered academic in nature because the assessment has been issued for not issuing the compulsory draft assessment order to the assessee. In the present case, the tribunal relied upon the Honorable Delhi High Court judgment in the case of Principal Commissioner of Income Tax versus Sumitomo Corporation India Private Limited, which is a 2024 judgment and which is reported in 166 taxman.com 55, and another Bombay High Court judgment in the case of International Air Transport Association versus DCIT, which is a 2016 judgment and which is reported in 290 CTR page 46. Friends, this case is also very important from the perspective that if there is some procedure in the law, then that procedure is to be followed and that work is to be done only in that procedure and not in any other procedure. So the procedure part is very important as far as the fiscal laws are concerned. At the end of this video, once again I am repeating the name of the case. The name of the case is Shri Prakash Kundan Das Bajaj versus Deputy Commissioner of Income Tax, Center Circle 8. The reference number of the case is ITA number 2797 Delhi 2026, and the matter has been decided by Delhi ITAT E bench on 13th July 2026. Thank you, friends.